It's 9:02 on Wednesday, April the 6th. The House Criminal Justice Subcommittee is now in session. Madam Clerk, please take the roll.
Representatives Beck, here. Curcio, here. Farmer, here. Griffey, here. Hardaway, Howell, here. Lamberth, Farmer. Moody, here. Russell, Sexton, here. Chairman Doggett.
Present.
Chairman Doggett, you have a quorum.
Thank you, ma'am. Members, do we have any personal orders before we begin on this beautiful spring day? Zero. All right. We'll go to our Sergeant of Arms, Mr. Tyler Muniz, for our final installment of our weekly Words of Wisdom.
Good morning, everyone. With this being our final committee here, I thought it would be a good honor to use some words of wisdom from the chairman himself. He gave me the verse, Genesis 50:20. You intended to harm me, but God intended it for good, to accomplish what is now being done, the saving of many lives. This verse shows how God uses the difficult circumstances to bring out the good for ourselves and the ones we cross in life. He gives us mercy every day, so we should give mercy as well. We are called to be Christ-like and others-minded. Have a blessed day.
Amen. Thank you so much for that, Tyler.
Long time ago, Bill. Yeah.
I got really nervous when he said, the chairman gave me out of his own words, and I thought, oh boy, what have I said? But very good, Tyler. Thank you so much. All right, if you will, let's take a little journey through our calendar to take care of a few things before we begin this morning. Number 3. If you'll go with me to item number 3, House Bill 1936 by Chairman Curcio. That is going to be off notice. Item number 7, House Bill 2586 by Chairman Curcio. Off notice. Item number 11, House Bill 2815 by Representative Hardaway. Off notice. Item number 13, House Bill 2799 by Representative Miller. Off notice. Item number 16, House Bill 1830 by Representative Parkinson. Without objection, we'll roll to the special calendar. Item number 17, House Bill 2254 by Representative Harris. Off notice. Item number 19, House Bill 1008 by Representative Hardaway. Off notice. Item number 20, House Bill 1318 by Representative Hardaway is off notice. Item 21, House Bill 2807 by Representative Hardaway is off notice. Item 22, House Bill 2809 by Representative Hardaway, off notice. Item number 23, House Bill 1 by Representative Hardaway will be off notice and moved to the special calendar. So, with that being said, let's go back to item number 1, House Bill 325 by Chairman Curcio. You have a motion and a second. There is an amendment.
Thank you, Mr. Chairman. Yes, I wish to move amendment coded 14663.
Second.
You have a motion and a second on the amendment. Proceed, please.
Thank you very much. Members, some of you may know for the last couple of years, I think Leader Lamberth has had bills, I've had bills, the members before us have had bills to try and restructure what's called the EMIF, or the Electronic Monitoring Indigency Fund. There have been several entities of this fund over the years. Its current posture is that Interlock, which is a completely different technology than all of the other electronic monitoring technologies, gets first dibs on the money that's appropriated and generated by fees, and then the money that's left over pours over into the Electronic Monitoring Indigency Fund, the EMIF fund, which goes to pay for indigent defendants who are on a GPS monitor, a transdermal monitor, some other type of electronic monitoring device. The issue with that is that we have an undefined number of claims for an undefined bucket of money, which means at some point mid-year we typically run out of money. And it's been a big mess that we've tried to unravel over the last several years. There was an effort 2 years ago with the administration to try to get a bill that would fix this. We've not been able to come to a good place on that. And so what we've done this year in consultation with my Senate counterpart is we are actually going to put in code the creation of an Electronic Monitoring Indigency Fund task force to study and make recommendations on the future of the Electronic Monitoring Indigency Fund. And so what the amendment before you does is it describes the makeup of that task force, and it also sets the deadline for which they've got to come to us with a workable solution that then this committee can talk about the merits of. So with that, I move passage.
Thank you for that explanation. Any questions for our sponsor on the amendment? Seeing none, we're now voting to add Amendment Code 14663 on the House Bill 325. Those in favor say aye.
Aye.
Those opposed, the ayes prevail. You adopt. We're on the bill as amended.
Thank you, sir. I renew my motion.
Any questions? Seeing none, we're voting to send House Bill 325 to full criminal. All those in favor say aye.
Aye.
Those opposed, the ayes have it. You move on. Thank you. Item number 2. House Bill 2526 by Representative Sexton.
Motion. Second.
You are recognized. There is an amendment, Code 13435. Do you wish to proceed with that?
Yes, I do.
Second.
You're recognized on your amendment.
If you'll give me just a few minutes, I'll try to explain the purpose of this bill. In 1983, the Transfer Control Protocol, the Internet Work Protocol, commonly known as the TCP/IP, was established. Under the TCP/IP, every device connected to the Internet had its own unique address. So every computer, every phone had its own IP address. With more and more Internet cable devices, such as iPhones and other smartphones, tablets, and interactive game consoles, connected to the Internet, they ran out of these unique IP address numbers. So in order for them to continue on, they had what they would call multiple users on one IP number. So these temporary IP addresses are only assigned while the user is on the device and not when they're logged off. As soon as the user of the device logs off, it frees it up, that temporary address, for someone else to use. The problem is using these temporary IP addresses can cause issues. And in other words, you don't know at any given time after it's been used who that person was. And so this bill came to me from a detective in my county, Claiborne County, and he worked on trafficking and child pornography and those issues, and he was not able to go back and find the individual that was using this because they had multiple users for one number. And so prior to them running out of numbers, they've been using these multiple users on one number. And so what we have now is we've got a situation where we've got the new numbers that can be used. It's my understanding it's a little difficult for them to spend the money and the time to update their devices to use, to give everybody or every device, such as an iPhone, its own unique number. Problem is that it's causing law enforcement the inability to be able to track down trafficking and child pornography and those type things. So I don't know, Chairman, I don't know if we have someone, I know we had last week, someone here to speak on it, but we didn't get to the bill, so I don't know if we have anybody that's wanting to speak on it today or not.
Yes, sir, Representative. We do have, I do have a list here to speak. Do you want to go out of session before we adopt the amendment, or would you?
I'd like to adopt the amendment first.
Okay. Question's been called. Any objection on the amendment? Seeing none, we're voting to adopt Amendment Code 13435 on the House Bill 2526. Those in favor say aye. Aye. Those opposed? You adopt. We are on the bill as amended. Any questions for the sponsor on this before we go out of session?
I would like to say this, if I could. What this bill does is it requires the providers of these numbers to keep that data for a certain amount of time in order for law enforcement, if they need to go back and check someone, they'll have that information. There are some issues. I feel like they're small issues, not large issues, but we can get into that and talk about it. But that's what this bill would do, would just require them to hold on to those individual tracking numbers for a certain period of time.
Okay. Thank you. Chairman Farmer.
Yes, real quick. Thank you, Mr. Chair. And Representative Sexton, how long are you asking these providers to hold this information? Because I think it really matters in this day and age with all the devices we have and all the technology and everything that's up wherever in the cloud. So how long are we asking these folks to do this?
Originally, we were asking for a year, and to be honest, I don't know if we got that language put in the bill or not, but I'm certainly willing to. I see them shaking their heads, so a year, yes.
Okay. All right. Thank you. Thank you, Mr. Chair.
Thank you. Any other questions? Yes, sir.
Thank you, Mr. Chairman. I'm hearing some concerns about this, and I'm interested to hear the speakers who's going to be presenting today. But I've heard some concerns from the industry that we would be the first in the nation to require this by law, and that some of the providers, the system providers, they don't track people by Tennessee residents or whatever. Their traffic is nationwide, and that trying to impose this upon them may generate huge cost and just a logistical nightmare as far as operating their system. So I just wanted to at least share those concerns that I'm hearing from the industry, and let's see what our guests have to say about this. So thank you, Mr. Chairman.
Let me share. I have spoken with some of the providers as well, especially the smaller providers that will probably impose.
Turn your mic on.
I have spoken with some providers, mainly the smaller providers, that it would probably impose the greatest hardships financially upon. But they can do this. There's one provider that's very concerned about child pornography, and so he is able to go back and trace it. However, it does require time and effort on their part. Or the other option is, which I think is inevitable, that we're going to have in the future a number for every device. The technology's already there. They would just have to, spend the money to update. Here's what I was told by the FBI. If we're concerned about, and which I am, I'm concerned about Big Brother watching me all the time, but what they have to do now is they'll have to take 500 or 1,000 IP numbers, or people, rather, that would use one number. And they have to go through all their information and sort through it till they get down to the one that they want to get to. So it's causing a lot of money and effort now. This would kind of solve that problem, but either way, you're going to spend money. We're spending the money now to go through all of these different individuals to find the one that's doing the trafficking. So this would help solve that problem. Causes other problems, of course, financially, but we're spending dollars now trying to get to those numbers.
Thank you. Any other questions before we go out of session? Okay, we're going to go out of session. First on our list is Mr. Dennis Wagner. And if it's okay with you all, that I'm going to call up three of you at a time. So Mandy Young, Lou Alsabrooks. We'll give you 3 minutes each to speak on what your thoughts are. But if you would, please introduce yourself for the record, and then you'll have 3 minutes each to speak.
Mr. Chairman, I'm Mandy Young, and I represent Verizon Wireless. Y'all want to introduce yourselves?
Have the light on. Can y'all hear me?
Yes.
Okay. Mr. Chairman, Lou Alsabrooks, and I represent U.S. Cellular here in Tennessee.
Dennis Wagner, Director of External Affairs with AT&T.
And Mr. Chairman, we'll be very brief. As a wireless industry and also a landline industry, while we understand the laudable goal and appreciate the intent of the bill, currently we are not able to do what Representative Sexton's bill asks us to do. If law enforcement gives us dates, times, and other information, we can triangulate it to that one individual, part of the IP address. But there are not enough IP addresses in the world. So we have to recycle those. So without a date and time and other information, we can't figure out whether it's Representative Sexton or Representative Russell. In fact, each of us, when we are sought the information, reply back to the subpoenas or the request to law enforcement with the needed information that may be needed to go deeper into the 5,000 people or 100 people that are sharing the same IP address. So we have departments in our companies that are willing to do that and work with law enforcement regularly. We have law enforcement training sessions to help them do that as well. But currently, because there's a shortage of IP numbers and IP addresses, which is way above my pay grade as a lawyer and a lobbyist, then we can't get down to the detail of who that individual is that was on there without further information that we provide to law enforcement at that time. And I'm happy to answer any questions or let my competitors also speak.
I think I've got a fourth grade education. I can turn that on. I don't have anything to add to what Ms. Young said. We're here today on behalf of the industry as a whole. U.S. Cellular is one of the smaller providers in the marketplace. We're in about 24 states, and we're only in about half of the state of Tennessee. And I agree with everything that Mandy just said. I think it's certainly a laudable goal with the legislation, and certainly something that needs looking into. But just right now, after speaking to our folks at U.S. Cellular, we literally just cannot do this at this time. I think it's just a technology issue. So that's all I have on that.
Thank you, Mr. Chairman, members of the committee. I do appreciate the opportunity to address you this morning. And as my colleagues have said, this is a laudable goal. We have no opposition to the idea behind it. It's just at this particular time, it's just not feasible for us to be able to do what is being asked here. Would certainly like to sit down and work with the proponents of the bill and others that are interested in this to sit down and see what could be worked out at some point in time. But my company is, let me know that this is just not workable at this particular time. So appreciate the time.
Thank you for your comments. First on my list is Chairman Curcio.
Thank you, Mr. Chairman. And I want to try to clarify something in my mind, and I don't need the MIT graduate level description. I'm not asking for that, but in my limited understanding of how any of this works, I have always thought that an IP address is kind of like my social security number. Like at some point when I entered the cell phone world, I was assigned one, and it sort of follows me like my belly button everywhere I go. I'm hearing, though, that that's maybe not the case. Can you help me understand how IP addresses work? Again, I don't need the master's level degree, but generally, do I get one and it's mine forever, or how does that work?
Mr. Chairman, Mandy Young again, and I cannot even give you the short version of the summer school remedial class, except that you don't just get one. And currently, because of the internet, there's versions of IP addresses, which I've just learned in the last 36 hours since we learned about Representative Sexton's bill. There's an IPv4, there's an IPv6, there are letters and numbers and a combination. An apartment complex can have one IP address and 200 people using it. And then there's different information between the internet service providers like ourselves or mobile services. There's difference between landline and synchronous, which Chris can explain, and asynchronous, which is mobile, which can be a mobile device being connected to other locations. In addition, it matters to what internet site you go to, and there's data on the other side that connects that helps identify the IP address to that web browser, web user. And I've just talked more than I really understand, but that it is not a social security number. You will not have the same IP address for the rest of your life.
Thank you. Moreover, it sounds like I may not have the same IP address all day today.
That's right.
Okay. All right.
That's right.
Thank you very much.
Representative Sexton.
Based on the information that I have received, everything that you're saying, I disagree with. And I don't have any way of proving that because I don't know the industry. It's just I'm hearing conflicting reports about this. One is that the numbers are available now.
Is that a question?
To give everyone a IP for every device. That technology and those numbers are available now. So I can't tell you whether it is or not, but I am being told that it is. And by the way, none of you came to my office and talked to me about this prior to this meeting, so we're having to hash this out now.
Yes, sir. Some of us tried to reach out and some of the industry has talked to Nicole, and for that we apologize. We were unaware as an industry of this amendment till it went on in Senate Judiciary last week because the industry had not been consulted by whoever you were working with, Representative Sexton, and we apologize that we didn't get back to you further. I believe, and I'm not 100% certain, that this cell phone may have an IP address, but it matters what internet service provider you're using at the moment, if you're using Wi-Fi in a building at a moment, and what web browsers you are connecting to. That is above my pay grade. I'm being told by Verizon Wireless, we cannot comply with your bill as it is today because we do not have all that information. We do keep our information and for a period of time, and each company has its own business practice as to how long we keep it. We are happy to share what we do keep with law enforcement and do today based on subpoenas or court orders. In fact, Verizon has over 300,000 requests from law enforcement and court orders across the country. And we comply with all of them, and upon responding back to the subpoena, if they need it to further drill down to whether it's Representative Sexton or Representative Russell, then we ask for more information from law enforcement. And if they obtain it from the web user, like a Facebook could be one of those places, then we will be able to help them further identify which of the individuals under that IP address actually was the one that visited that site.
Well, two things. One, the question was, are those numbers available?
I believe that the TBI testified last week in Senate Judiciary, and I've only read the testimony, that we are out of IP numbers in the world.
Okay.
Okay?
Okay. I'll take
And that's
that.
why we're recycling them.
And I don't know. I don't know.
Either, Representative Sexton. I'm reporting.
I'm just being told by different people that we don't, and then others say that we do. So that's a question. Now, the other thing is you said that you work with law enforcement and you're able to draw down to find that individual. So to me, that's conflicting with what you said a while ago, that you're not able to comply with that we're asking here. All this bill is asking is to keep that identification, that information for a certain period of time. So it sounds like you're doing that some already.
Representative Sexton, Mandy Young again, and I'll just show you that this nice little pretty chart that Verizon sent me, I'm happy to provide it to all of you. It is what we provide to law enforcement. We ask for further additional information from law enforcement dates and times and locations. And once we get that, we can draw it down. It is not that we don't want to help them, Representative Sexton. No. It's that we don't contain or possess the information until they tell us further follow-up information, if that makes any sense. And I like you, am being told by my client that we can't do this. And we spent an hour and a half with the experts in our company on the phone yesterday morning. And my eyes were glazed over afterwards, but I've learned a lot in that 48-hour time frame.
And I share that same sentiment with you because I'm getting the same conflicting messages of it can be done, it can't be done. We do have the numbers, we don't have the numbers. And based on the information that I've gotten from law enforcement, that it is being done. It's just taking them a long time to go through all of the numbers, or not all the numbers, but all the individuals. Just like to make a little point. This thing follows me everywhere I go, and GPS tells me where to turn and knows where my house is and can get me to places that I haven't been. It tracks you second by second. And so if it knows where I am, I mean, there's something going on, and I know that we watch enough detective shows that tells us, you know, that it pings off this tower and it pings off of that tower. Seems that it's not, and I'm talking from an elementary level here, doesn't seem like it's that complicated from my world that we're already doing it. And we're just asking to obtain information until we get these new IP numbers. And I would like to ask that question too. Are you aware that there will be enough numbers in the future? That's what I'm being told.
And Dennis Wagner, AT&T. I have not been told that by my company experts. Again, just the fact that we're not able to keep those addresses for that period of time, millions and millions and millions of calls across the country, of course, and to store it all is just not feasible at this time. But to answer your question, I don't know about the number situation.
Have you ever asked?
No, I have not asked that specific question, but we'll do so.
I'm good.
Leader Lambert.
I want to just clarify something. So I think all of us have had the experience of either saying something about an item that you might be purchasing at the home or purchasing said item. It's real fun even when you're buying birthday gifts for somebody else or something and you get push advertisements for blah, blah, blah that you purchased for somebody else. It wasn't for you, but that data seems to be pretty easy to maintain and sell and transport around to lots of different people. I'm not hearing any of y'all say that you don't want to comply with this. It's just as written that you're not able to. I mean, it sounds like the data is out there, right? Because just like, you know, my example of purchasing something online and then getting push advertisements, I mean, obviously they're keeping that data and it is identified to me somehow. Because again, they're more than happy to push out that, you know, I bought a weed eater for somebody and, you know, I don't need another weed eater, but it doesn't matter. I get advertisements on it for the next 6 months. So, I mean, if that information is out there, is that basically what you all are saying, is that you want to comply with law enforcement, want to comply with these judicial subpoenas, go after the bad actors, but just as written, you don't have this data?
Representative Lamberth or Leader Lamberth, I think that's accurate. I think that when law enforcement can come back to us with more specific information, like there are 5,000 users at this IP address today, but we need this date and this time and this port number, this blah, 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 there's a whole chart, then we can help triangulate as they break down to it. We don't break down from a privacy perspective every user and store that information. It's a little bit like text messages. We used to keep them for 10 days, 10, 15 years ago. Now we can't even keep them for 72 hours because of the number of data centers and servers we would have to have and build to keep your information in our servers. So there's some privacy issues as well, but we work with law enforcement and send them back, at least Verizon does. I assume my competitors do. The other information, if you want to go below that 5,000, please provide the following. We have an entire department, that's what they do across the country.
Sure. And so just to follow up then, again, there's a way to get to this. It just isn't the way that it's written currently, is what I'm hearing. Is that look, with working with law enforcement right now, if these several factors are met and the information is requested in detail, then there's a way to get to that information in essence, just not this way. Is that fair enough?
I think we'd have to bring in our experts, Leader Lamberth. I'm being told that we're already cooperating and we don't need a bill to tell us how to cooperate because we're already doing that. And because we weren't brought in on the front end and we didn't have a lot of time between last week and this week to get to the problem, I'd love to know what Representative Sexton's detective had problems getting and why, and what information he gave whatever carrier it was and what they responded back to. I mean, we have a whole department of exigent circumstances. It's a special number that you can call if it's an exigent circumstance. I learned that because I Googled Verizon, because I was trying to learn more today about this issue, and I was digging into Verizon's website, and it's got an entire section that teaches law enforcement how to get it, and here's a phone number. So we want to know what problems we're trying to solve, and we are happy to sit down with law enforcement, the TBI, and everybody else to continue to work on this. We are not trying to keep the information from law enforcement.
Good. Well, and that's what I wanted to hear, because I know that of each of you and of your companies. And I hate that this bill is coming so late in the session, quite frankly, and it's nothing on the sponsor. It's just, look, these bills come when you get them ready to be able to present, and as long as we're here, we're still here to do the work of the people. But this one does seem like that everybody's cooperating thus far, and if there's a better way to do it, I'm all for it, because I think all of us, you all included, want to make sure to be able to get to the information of someone that is misusing the internet or their cell phone for criminal activity. And so, I mean, I know that's what the sponsor wants to get to, and so I appreciate the information you all shared today. Thank you.
Members, I do have others here that to testify on this. If you have a question, I've got some on the list specifically for them, or if it's one in general. You have one specifically for them, or is it just an in general question about it? Okay.
So this is for all three of y'all. Are y'all fulfilling subpoenas through Tennessee law enforcement agencies right now, and how many per year?
Mandy Young, Verizon Wireless, Representative Russell, we are fulfilling all the requests if they meet the criteria for a subpoena, and then we give back the information if they need to go further, what other information we would need. I'm unaware of any that we haven't fulfilled, and I don't know an exact number. I just know the national number.
And how many, I'm sorry, was you going to?
It's okay. Dennis Wagner, AT&T, same thing. We do fulfill all requests as far as I know. I do not have a number for you in the state.
And Lou Allsbrooks with U.S. Cellular, Representative Russell, exactly the same. I hate to be the one nodding my head in agreement, but we always are going to comply and do everything that we can. I can try to get the numbers back to you. I can't get them right now, but while I'm sitting up here, but we can certainly work with the sponsor and continue to work to try to meet the goals of this. It's the time crunch, I think, is just what we're dealing with right now. Thank you.
And how far can each of your all's company go back to retrieve data from a subpoena?
From AT&T's perspective, it varies. It just depends on the request and what we're looking for. But I don't have a specific answer for you, but it just does vary from days to months to years. Yeah.
Mandy Young, Verizon Wireless, the answer is the same. Representative Russell, we have basically a uniform retention policy for across the country because we operate in 50 states. And I believe we keep it longer than some of our competitors, but I think that's a moving target.
Yeah.
It's a voluminous amount of information.
And I would just concur with what Dennis and Andy just said, exact same thing. So,
thank you.
Yes, sir. Representative Sexton.
I just want to get this on the record that law enforcement, no one in law enforcement has ever said to me that any of the providers has not worked with them, that you've always been very cooperative and help them any way that you can. So I want to make sure that that's not the intent here to ask you to do something that you're not willing to do. Every company, from my knowledge, from a law enforcement standpoint, has been extremely helpful. The purpose of this bill is to see if we can find an easier way for law enforcement to get to that individual. Right now, they're having to sort through hundreds, thousands, tens of thousands of individual people to find that date and time. And I think you've all agreed that there is a way of getting there. And as Leader Lambert said, how can we get there? What's the way to get there? One way is to provide those numbers or to keep that information. Maybe that's not financially feasible, especially, well, for larger companies or especially smaller companies. I think that at some point in the future, every device will have its own IP number, because everything that I've read and discovered is that is the future. Just like we had back in the day when this started in 1983. Every device had its own number. So we ran out of numbers. But anyway, I just want to make sure that no one thought that was the purpose of this bill. The purpose is just to find a way to get that information easier for law enforcement.
Absolutely.
Thank you. Representative Hardaway, do you have an in general or specific to these guests?
Specific for these guests, and my colleagues Russell and Sexton took care of some of it, but I want to make sure that I'm clear. We can have more than one user of an IP in the same day.
Yes, sir.
Okay.
Mandy Young, Verizon, sorry.
And the work that you do with law enforcement now, there's information that you retain for a period of time, and some of that information may be retained longer than others. Help me with that. The information that in general law enforcement would need in order to narrow down on the IP and other subpoena requests.
And this is above my pay grade, Representative Hardaway, but it was explained to me that I could approach websites at different locations during the day and use multiple IP addresses on this. So imagine how many people in Tennessee have not one, but many people have two phones, a work phone and another, and they're going through the Verizon service or the AT&T service to get to an internet site that has its own information that knows I went there. So it is a moving target all day long for you and me and everybody else that has their phone on the IP addresses. That's what I was told.
Okay, US and AT&T.
I would just concur with everything that Mandy just said. Representative Hardaway, it's a complicated, very technical thing. If it's above Mandy's pay grade, it's so far above my pay grade. I can't, but that's correct. So.
Same thing, Representative Hardaway, Dennis Wagner with AT&T. I'm not the technical expert here or anything like that, but it's a variety of things that affect, what is retained, what's not retained, or how long it's retained.
Well, I guess it's a good thing you're here, Mandy. Mr. Chairman, that's all I had specifically for them.
Thank you. We're going to go to Representative Howe for the last one on this panel, and then I've got two more guests that will be available as well. Representative Howe.
Thank you, Mr. Chairman. I've been sitting here listening to the conversation and trying to simplify things in my mind, which is hard for me, some of you who know me. Let's say I'm sitting at my desk in my office and I have a computer that's plugged into the wall, and I send my wife an email today, and that would be one IP address. But if I do the same thing tomorrow, it would be a different IP address?
Could be. It could be, we think, but it might not be. It could be the same one.
Mm-hmm. So those are recycled potentially?
Yes, sir.
Okay.
And that question may be better answered by the telephone cooperatives that are coming up next if they get here, because Chris probably knows the answer to that, and that's above my
And I would
pay grade
assume,
again.
I'm sorry, Mr. Chair, I would assume the same thing would be true if I use this device, or if I use this device to do the same thing. Okay.
Yes, sir.
All right, that helps. Thank you, Mr. Chairman.
Thank you. Thank you all for your time and for answering our questions and concerns. Next, we have Mr. Chris Townsend and Ed Massey. Gentlemen, if you would introduce yourselves for the record, and you'll have 3 minutes each to make your statements.
Thank you, Mr. Chairman and committee. My name is Chris Townsend. I serve as the CEO of DTC Communications and also the president of the Tennessee Broadband Association. I work with Mr. Lavoy Knowles, that most of you, I'm sure, know, that see around quite a bit. DTC is based in DeKalb County. We also provide service to approximately 15,500 homes and businesses in rural Cannon, DeKalb, Smith, portions of Wilson, and portions of Rutherford counties, as well as work with statewide fiber networks.
Ed Massey.
You have to hit the button. There you go.
I am Ed Massey, the Network and Central Office Manager for DTC Communications.
And Mr. Chairman, if I may, I'll say that I heard the comment earlier that I believe someone said it maybe not an MIT. They weren't looking for a MIT discussion. Mr. Massey is not MIT, which I think we're probably glad about. But he is Tennessee Tech graduate and holds over 20 industry certifications. So I hope that we can help answer some of the questions that have been asked if still needed.
Thank you. Representative Griffey is first on my list.
Thank you, Mr. Chairman. I have a couple quick questions. I hope, if we pass this, would Tennessee be the only state that has enacted something that would require the logging of user data logs?
Representative Griffey, there are already multiple federal laws that require logging of data that is similar to this. This bill is very specific to CGN technology. And the CGN technology, it's not looking at just one single IP address with multiple users under it. It is all of the devices that flow under that. So you're having to look at approximately 64,000 ports per IP address. So my answer would be very clearly that it is an extremely granular ask that the bill is presenting. We personally are not aware of other states that have this. However, I will say that I do not know of a federal law either requiring this. I will say that from a state standpoint, I personally learned about this bill Friday, and even though we were on Friday afternoon with folks in Washington that we trust highly, they don't know of any, but I've not had time to do adequate research, so that's my answer, Mr. Griffey.
Thank you for that. And so the data may be out there, but it's not retained or essentially by any providers in a format where it's a specific user log where law enforcement could simply give you a name or give you an IP address or give you the identifying website, whatever, and track it back to a particular user. You guys just don't store the data in that format at this point in time. Is that a fair assessment?
I think that's a fair assessment, and Mr. Massey may want to speak to that more specifically. Much of the data is there. Again, when we talk about storing that data down to every single port level, even if we stored that in that level, Mr. Griffey, with, as Mandy had said previously, without additional information coming in the adequate form through the subpoena process, we still couldn't give the information out. I'll say it this way. When you look at an auto manufacturer in a very enclosed environment, they provide systems that exist today they operate almost to perfection, and they can track every single packet from end to end, where it was at any given time, where it started, how it landed. The internet is anything but a controlled environment. It is the wild, wild west of data transformation, and where a phone line, for example, under CALEA compliance, has a synchronous route, one route, two endpoints. It's easy to tack onto that and track that information. If you try to send data or receive data, whether that be an email, a website, whatever, those packets may be split and go into have millions of different possibilities of routes and come back together on the other end to create the image or the data that you're looking at on your screen. The issue with that is that the prioritization is of the content of substance, not necessarily the logs as well. So you don't always get good log data, even if you get the intended, information that was sent on the other end. So what I'm saying is, even if we built the greatest storage system that's ever been that could look at all 64,000 ports for every single IP address and tracked everything for every day forever, I still cannot certify under penalty of perjury that I can tell you that Representative Farmer had, for example, a certain address operating at a certain time. It will always be best effort over a period of time because of the dynamic nature of the internet. And I'm not trying to be very technical or complex, but it is a very complex issue.
Last question, Mr. Chairman. And would it cost you, the industry, millions of dollars to comply with this law if it was passed?
My
in its
small
current
company,
form?
with about 15,500 customers, initially, it would cost us probably $250,000 to build a system to start this process. Even for my company, it would. We're estimating $50,000 per year in annual maintenance on those servers. I've been at two cooperatives in my career. Both have had wireless companies with around 20,000 users. It would be more complex for the wireless industry. I don't operate those anymore. I have no doubt it would cost millions upon millions for companies to do this, and I doubt, I'm not going to speak for nationwide carriers at this point.
Thank you, Mr. Chairman. Thank you both for being here. Thank all our guests.
Thank you, Representative Hardaway.
Thank you, Chairman, and good morning, gentlemen. It sounds like what you're saying is you keep a macro database, and when you get the subpoena, you go back and you use it to narrow down to the specifics within the subpoena. Is that correct?
Yes, sir.
Middle one.
Yes, sir.
All right. So you're saving data. You're just not saving it with the specifics that my colleague is looking for right now.
Yeah, we're not, Representative Hardaway, we're not saving it in the specific format down to the second. And the reason we're not doing that is because, first of all, we don't know of anyone in the industry that does it that way because the law has not required it. But in addition to that, we don't do it that way because it's not an efficient way to operate the network or hold the storage. So here's what we're saying. For example, I get a subpoena today that has just an IP address. We, in our company, can narrow that down to 40 or fewer users at any given time already today. It's a different setup than the wireless companies, but it's one of 40. Then what we can do is we can go back to the company, and we do this already. We've done it with TBI, we've done it with local, we've done it with federal. Can you provide a port number, which is very specific? That's the one of 64,000 on the other end. Even if we're looking at that data or storing the port numbers, we still don't know which port was used until we get that information through the subpoena process. So that's got to be stronger before more info can be provided. So to be very specific, we are storing the information, not technically exactly the way the bill would require, but even if we did it the way the bill requires it, I don't know that we can provide any additional information today if more info is not brought in through the subpoena process. We'll go back and forth 3 or 4 times with law enforcement and say, and we fully respect, they don't want to give you a name. They may have a name, they think, but they don't want to give you a name yet. Well, we'll get it down and say, okay, we had 3 users of that IP address on this day during this 6 hours. Can you tell us if it was a Smith, a Jones, or whatever? And if they can tell us any additional, we provide that. Or we could provide the 3, and then they take it from there. So we're already doing that today.
And are you developing new search techniques, new technology that you're using to search those databases that will allow you to narrow it down in a faster fashion? So I'm assuming that that's part of the issue here is how long the turnaround is each time that you're given new information to search.
Yes, sir. There's using what's called IP version 6, and what the traditional was originally, the one that's ran out of the IP addresses. We are working to continue to deploy that into networks. However, the internet of itself isn't fully adapted to being able to use that technology. So if someone is trying to reach a website somewhere that hasn't adopted that technology, then it wouldn't work. So therefore, they wouldn't have no internet connection at that point. So, but we are working to deploy that and make that even more reliable within the network.
Mr. Hardaway, may I respond to that as well? So I think this answers Representative Sexton's question as well from earlier about are there enough IP addresses? Are we out of IP addresses, and are there enough IP addresses out there? The world has been out of IP version 4 addresses since approximately 2010. That's why you have these additional technologies to layer this in. IPv6 is available today. It is not the carriers that are stopping the adoption of IP version 6. We utilize both in our networks today. The websites on the other end, the people that are creating content on the internet are the ones that have to adopt IPv6 because it's the new technology. So are we developing systems that are better, faster? Yes. When IPv6 gets here in full across the world, this will no longer be an issue. Representative Sexton actually said he's been told the same thing. We don't know how fast that will be fully adopted. The problem is this bill is very specific to CGN providers, which we happen to be one, and asking to build a database that's so detailed and complex that even if we build it, which by the way, we can't get the equipment to build it because of supply chain for the next 300 days. If we tried to build it, even then, we can't provide the data down to the second with a guarantee that it's accurate. And that's just because the nature of the way the systems are designed.
All right, thank you, Mr. Chairman. Sounds like the fire has been lit by Representative Sexton, and they're feeling the heat. So
yes, sir.
I think we'll have this problem solved shortly.
Thank you. I'm going to have two more on the list, and then we'll go back into session. Representative Howell.
Thank you, Mr. Chairman. Thank you, gentlemen, for being here and providing some clarity. I just wanted to pose my question again that I proposed to Ms. Young. I think you answered it a while ago, but I just want to be sure. If I sent my wife an email today and then send it from my desktop that's plugged into the wall, sent another email tomorrow, would it show up as the same IP address?
So there are multiple answers, but I'll be very simple. If you had a static IP address, which it was assigned and paid for by you, it could be the same address over a long period of time. If you have a dynamic or DHCP IP address, it can change every time the lease renews. That can be a power cycle, a trouble, something else happens. It could be the same or be different. And if you have CGN, it will fall under the same IP address for us under 40, but it will change as well. And so it may not change. Our customers may not change for 30 days. They may change every 30 minutes. It's all according to, it's dynamic of what's going on in the network itself.
But if I understood you, even though I send the email on 2 different days, it may take 2 different routes.
Yes,
like
sir.
me going to Chattanooga, I might go down 24, I might go down 111.
Yeah.
I still get there, but it'll take a different route.
And it actually may cut your car into 1,000 pieces and go 1,000 different routes and come back together on the other end is probably a more accurate description.
Okay.
Yes, sir.
Thank you, Mr. Chairman.
Representative Farmer.
And thank you, Mr. Chair. All right, I hope you guys can answer this, and if I go off in a weird way, then just stop me. But I thought it'd be good for the community to hear this and understand that this. So as I see it, this IPv4 was the initial way that all these millions and millions of IP addresses were. And they thought that was going to be enough when the internet was invented, right?
Yep.
Like, okay,
It's
no
been
way
said. That's right.
There's no way in this world we're going to use all these IPv4 addresses, millions of them, billions maybe. So then they realized back in, I guess, around, well, it says on Wikipedia here, February 3rd, 2011, they ran out, all right? And they had a few left, and they released those, and then in April, they ran out of those. Then they started this recycling technology. Throughout that time, they did the recycling technology. They had been working on the IPv6, which is going to provide exponentially more than IPv4. But the point I'm getting at, what I'm reading here is you just can't flip a switch and go from 4 to 6 because they're not interoperable, right? So that means you can't just say, okay, we're going to go from 4 to 6 tomorrow. Boom, everybody's using 6, the 4s are gone. It sounds like there's some sort of phase-in process. And according to what I'm reading, it looked like it says here on Wikipedia, completion of IPv6 deployment is expected to take considerable time. So do we have an idea of when 6 may be fully deployed? What and that, and if ever? Just kind of curious there.
I believe it will be in time. However, we don't know exactly how long it will take for all of the websites and the hosting to be able to have their services installed with IP version 6 to be reachable. So we do not know. Several years.
And is that something that, Mr. Is that something that everyone collectively is working on? Is your company working on that? Is that the goal, the end goal, to be IPv6 sustainable, or however you want to put that?
Yes, sir. That is.
Okay. All right. Thank you, Mr. Chair.
Last one on my list is Representative Russell.
Thank you, Mr. Chairman. And how many subpoenas in Tennessee do y'all get each year?
I've received 4 to 6 a year.
And are you able to fulfill the information on all those?
We were able to provide information back. Sometimes we're not able to make an exact one-to-one relationship. However, we're able to provide information back to them with requests.
And what type of material can you provide law enforcement when they request it, as far as sites people visit or what they're viewing?
No, sir. It would be that this individual IP address was used by this subscriber on our network with this hardware device inside their house.
So you couldn't tell the exact site a person was going to even be viewing child pornography or anything like that?
No, sir.
So if I'm understanding you right, it would be better for law enforcement to take a search warrant out for the device to see if child pornography is being viewed on a device other than what you're providing them.
Yes,
is that
sir.
correct?
That would be.
That's all I got. Thank you.
All right, thank you, members. Thank you for being with us today in your testimony. We're going to go back into session. We're back on House Bill 2526 as amended. Any questions for the sponsor? Representative Griffey.
Thank you, Mr. Chairman. Based on what we've heard today, I think maybe if we want to move all the states in the world along on IPv6, maybe we ought to incentivize the creation of websites or that do that, or disincentivize those that are still using the IPv4 version and try to move the industry in that direction. But with that being said, based upon everything we've heard today, I think this bill is not ready. There's too many complications that I'd move for a summer study.
That is a proper motion. It has been seconded. Representative Sexton, do you have any comments?
Yeah, I prefer to take it off notice. Can I do that?
I withdraw my motion for summer study.
Okay, motion for summer study has been withdrawn. Representative Sexton.
Yes, I'll just take it off notice. I should have asked, and I guess I did. Maybe I didn't get the answer, as Leader Lambert said, and I think I did ask the question, is there a better way to get there? Personally, I believe that there is. I don't know that this is the right direction, but I would like to see something done to enhance the ability to go after these bad users. And so I won't be here next year, so I'll just let somebody else pick it up and do some investigation. Thank you.
Thank you. Without objection, House Bill 2526 off notice. Move to item number 4, House Bill 2040 by Chairman Curcio.
Motion.
Second.
You are recognized. You have an amendment 16696.
Yes, sir. I wish to move amendment coded 16696, and it makes the bill.
You have a motion and a second. You are recognized on the amendment.
Thank you, Mr. Chairman and committee members. This is actually an effort that I started my freshman year when I was first elected over in the Legislative Plaza, looking at creating baseline standards for criminal monitoring companies. So again, we're not talking about interlock here, and this amendment specifically excludes interlock providers. This we're talking about folks who are doing transdermal, GPS, other types of electronic monitoring. What we know is that this technology changes every day. There are now, pieces of technology that can be worn on your wrist that you can attach to an iPhone that can, track folks and make sure they show up for court. I mean, so there's any level up to, high-risk offenders all the way down to low-level folks that just need a reminder to get to court. But there are no baseline standards. And so when I started this, I admittedly went about it, I think, the wrong way, which was using a congressional research report. I looked at sort of baseline standards for pieces of technology. But as I've just laid out, the technology changes so quickly, you run the risk of passing a bill that's obsolete within 6 weeks of passing it, or you run the risk of picking and choosing winners and losers of one type of technology over another. So what the amendment that's before you does is it borrows from some of our neighboring states, creating baseline standards for how these companies who want to provide these services to government entities should behave, how they provide training, the types of requirements that they've got to meet as far as an insurance, general liability policy, and then also the directors and the employees meeting a certain standard of moral turpitude and not being having been convicted of certain crimes or pled to certain crimes. So that's what the amendment before you does. I'm happy to answer any questions, but again, this has been a multi-year effort to try and just create some baseline standards. Right now, I'm sure we've got a lot of very good actors in this industry, and I've met many of them, but we want to make sure that we don't have fly-by-nights coming in, renting devices out of the trunk of their car and then never monitoring the folks that they're supposed to be responsible for. So that's the purpose of this, and I move passage.
Thank you for the explanation. Any questions for the sponsor on the amendment? Leader Lamberth.
Thank you, Mr. Chairman. Mr. Chairman, I know you and I had talked about a couple different things in there that I think are just kind of clerical issues that are not major changes in the piece of legislation. And I just wanted to let the committee know that I'd talked to the chairman about this, and it's a noble effort. I mean, we've talked about this for years, the entire time you've been here. I'm just trying to make sure that you have a really high standard of anyone that is providing electronic monitoring. Most of the actors out there do a really good job, but at the same time, setting that high standard and making sure you don't have any bad actors is a very noble effort. So I appreciate you carrying the bill.
Thank you.
But I just want to tell the committee there may be some tiny changes between this week and next week. I do not in any way think it would hurt the bill, and it's mainly just clerical in nature. So, Mr. Chairman, thank you for bringing the bill.
Thank you. Any other questions? Seeing none, we're voting to add Amendment Code 16696 on the House Bill 2040. Those in favor say aye.
Aye.
Those opposed, ayes prevail. You adopt. We're on House Bill 2040 as amended. Any questions? Seeing none, we're voting to send House Bill 2040 as amended on the full criminal. Those in favor say aye. Aye. Those opposed, the ayes prevail. You go to full criminal. Item number 5, House Bill 2102 by Chairman Curcio.
Motion.
You have a motion and a second. There's an amendment 14285. You wish to proceed?
Yes, sir. Wish to move Amendment Code to 14285.
Second.
You're recognized on the amendment.
Thank you, Mr. Chairman and committee. Members, this bill actually came to me by Chairman Howell from his district attorney. Having seen the work that we did on expungement last year that this committee worked hard on, this is an extension of that effort. So this would extend those same changes that we made in code last year to anyone who was convicted prior to 1989, which, if you recall, was when we did the last large adult sentencing overhaul. And so this was pointed out that this was a group of folks that we overlooked, but it is certainly the legislative intent that it would apply to the exact same types of behavior, so not an expansion of current law in terms of who's eligible for expungement and who's not, but just reaching back and grabbing those folks prior to 1989. Be happy to answer any questions.
Any questions for the sponsor on the amendment? Seeing none, we're voting to add Amendment Code 14285 on House Bill 2102. Those in favor say aye.
Aye.
Those opposed, ayes prevail. You adopt. We're on House Bill 2102 as amended.
Thank you, sir. That the amendment made the bill. Renew my motion.
Any questions for the sponsor? Seeing none, we're voting on sending House Bill 2102 as amended on the full criminal. Those in favor say aye.
Aye.
Those opposed, the ayes prevail. Move on to full criminal.
Thank you, sir.
Item number 6, House Bill 2329 by Chairman Curcio.
Motion.
You have a motion and a second. You recognize there is an amendment, Code 16697.
Yes, sir. Late in session, a lot of captions. I apologize, but I do wish to move amendment coded 16697.
Second.
All right, you are recognized on your amendment.
Thank you very much. Members, this deals with the prevalence of cybersecurity incidents that have increased over the past decade. And so it's necessary to update Tennessee statutes on the subject. Our state cybercrime statute is known as the Tennessee Personal and Commercial Computer Act of 2003, and I think we can all imagine the changes that have happened with our personal computers since 2003, which are vast. So this bill, as amended, makes 3 changes to the act. First, it increases the penalties for certain offenses under the act to a Class A misdemeanor. The bill creates the new Class A misdemeanor offense of possessing a computer contaminant, otherwise known as malware. And finally, the bill, as amended, deletes a redundant section of code relative to the transmission of electronic signals by a local exchange company. And with that, I would move passage.
Thank you for that explanation. Any questions for the sponsor? Representative Beck.
Thank you, Mr. Chairman. My colleague next to me was wondering, does this mean we don't have to buy malware protection any longer?
Thank you, Mr. Chairman. I wish it did. All we can do is show that we frown on the behavior, but then it'll be up to law enforcement to stop people from doing it.
Any other questions for the sponsor? Leader Lamberth.
Thank you, Mr. Chairman. Mr. Chairman, I know I mentioned this to you the other day, but in this particular instance, where would the venue be on these crimes? Where would they be prosecuted? Because I know in the past we've had identity theft and theft issues that we specifically put venue in this state. And so if someone in another country or another state is trying to take advantage of one of our citizens, which happens in these instances a lot, does it specify where the venue would be?
Thank you, Mr. Chairman. This bill does not specify that, but if we could go to legal services, I think there's a more complete answer.
All right, without objection, we'll go out of service. Hear from legal services. Go out of service. I did it for the first time this year. I got us out of service on the last day. We're out of session to hear from legal services.
Michelle Fogarty, Legal Services. 3914-605 establishes venue for this entire part. And it states that for the purposes of venue, any violation of this part shall be considered to have been committed in any county in which any act was performed in furtherance of any transaction violating this part, and in any county in which any violator had control or possession of any proceeds of the violation or of any books, records, documents, property, financial instrument, computer software, computer program, or other material in furtherance of a violation, or in any county from which or through which any access to a computer system, or computer network was made, whether by wire, electromagnetic waves, microwaves, or any other means of communication.
Thank you, and that is exactly what I was looking for. So venue would be here, and we go after these folks. As another question, so some of these type of crimes are graded as theft. I mean, vandalism and theft are kind of graded. It gets worse as it goes up. Is there anything in this bill that would preclude someone from pursuing charges under the theft statute in any way?
No, sir.
All right, thank you.
Any other questions for legal while we're out of session? Seeing none, thank you. We'll go back into session. We are back on the amendment. Any other questions on the amendment? Seeing none, we're now voting to adopt Amendment Code 16697 on the House Bill 2329. Those in favor say aye.
Aye.
Those opposed, ayes prevail. You adopt. We're on House Bill 2329 as amended.
Thank you, Mr. Chairman and committee. The amendment made the bill, and I renew my motion.
Any questions for the sponsor? Seeing none, we're now voting to send House Bill 2329 as amended on the full criminal. Those in favor say aye.
Aye.
Those opposed, the ayes prevail. You move on to full criminal. Item number 8, House Bill 2805 by Representative Hardaway.
Thank you, Chairman. I'm having difficulty with my electronics today.
We will need a motion and a second on this. You are recognized.
And I'm going to have to ask Mr. Gleason what our decision was on that yesterday. All right, Mr. Chairman, 2805 is a bill that we've discussed the content. It deals with blended sentencing. It's a practice that I would hope that the state would adopt, whereby we appeal, not appeal, but we actually make use of the medical research, which suggests that your brain is not fully matured until the age of 25. Using that additional information in order to shape, design, and apply the behavioral modification programs that we do in the justice system, especially in the Tennessee Department of Corrections, would enable us to deliver justice both to victims and to the actual perpetrators of these crimes who are between those age groups. This bill needs more work. If my colleagues are interested in discussion today, fine. Otherwise, I'm going to take it off notice.
Thank you for that explanation. Members, are there any questions for the sponsor or comments? Seeing none, Representative Hardaway, you are wishing to take it off notice?
Yes, sir.
Okay, without objection, House Bill 2805 is off notice. Item number 9, House Bill 2806 by Representative Hardaway. You have a motion and a second. You recognize there are 2 amendments there, Representative. You want one, both, or none of the above?
Mr. Chairman, I'll take door 3.
Door 3.
Actually, I do want Amendment 15049, which creates a pilot program.
Okay. Need a motion and a second on the amendment. Second. You're recognized on your amendment.
Thank you, Mr. Chairman. There is a witness protection and relocation program that's currently operating in the state of Tennessee. It's actually in Shelby County. Thanks to work that our DA and the faith community has been able to do. When we have individuals who are witnesses at crime scenes, depending upon the area of town, depending upon the nature of the crime itself, quite often the investigation is stymied because the witnesses are fearful for their safety or the safety of their families. I have, Mr. Chairman, a letter from DA, District Attorney General Amy Wyrick, the 30th Judicial District, that she has written in support of House Bill 2806. With your permission, it's a short one. I'll read it into the record.
Yes, sir. Please do.
Dear Representative Hardaway, as District Attorney for Shelby County, I support House Bill 2806, Senate Bill 2716, and your efforts in this important area. The job we do as prosecutors depends upon the cooperation and participation of the victims and witnesses to a crime. Someone has to report a crime. Police need witnesses to solve the crime and build a case. Prosecutors have judges and juries to convince beyond a reasonable doubt. We are often faced with victims and witnesses unwilling to cooperate or participate. They fear retaliation, especially when they live in the same neighborhood as those committing the crimes. The result is too many violent crimes go unsolved and perpetrators remain free to victimize more citizens. Relocating witnesses and assisting them with fresh starts takes resources prosecutors' offices do not have. The pilot will help us get crime victims and witnesses out of harm's way and help us get violent offenders off the streets in our community by providing resources, support, and fresh starts. Amy Wyrick, District Attorney General. The way that the bill is rewritten, Mr. Chairman, the Office of Criminal Justice Programs will assist the municipalities, law enforcement agencies, and nonprofit organizations that provide witness protection, relocation, and assistance services in finding and obtaining grant funds from both public and private sources to facilitate the provision of the following to witnesses of crime: armed protection or escort by law enforcement officials or security personnel before, during, or subsequent to legal proceedings, physical relocation to an alternative residence, housing expenses, appropriate documents to establish a new identity, including documentation created in coordination with federal authorities, transportation or storage of personal possessions, basic living expenses, including food, transportation, utility costs, and health care. Support advocacy and other services to provide for the safe transition of witnesses into a new environment or other services as needed and approved by the office. We're asking the Office of Criminal Justice Programs to assist in developing the pilot program by giving guidance to the existence of grants and other resources that could benefit the pilot program and move it along. We're not asking that any funds be appropriated or obligated or expended unless the funds are specifically appropriated by the General Appropriations Act. That's in Section 2 of the amendment. With that, Mr. Chairman, I will entertain questions.
Thank you very much. Any questions for the sponsor on the amendment, Representative Griffey?
Thank you, Mr. Chairman, and thank you, sponsor, for bringing this legislation. It sounds like a good effort to try to address a problem that we see in many communities that are experiencing people unwilling to come forward because they're scared of retribution by the criminals, and we need to do something to address it, and I'll be happy to sign on to your legislation. Thank you, Mr. Chairman. Thank you, sponsor.
Thank you. Any other questions for the sponsor on the amendment? Seeing none, we're now voting to adopt Amendment Code 15049 on the House Bill 2806. Those in favor say aye.
Aye.
Those opposed, the ayes prevail. You adopt. We're on House Bill 2806 as amended. Representative Hardaway, there is testimony requested on this bill, but do you have any comments that you would like to make, Representative?
No, sir.
Okay. Without objection, we will go out of session. If you're Jennifer Brinkman. If you will, please, ma'am, introduce yourself for the record, and you will have 3 minutes for comments and then be available for questions. Is the red light on down there?
It was on. I thought that meant off. My name is Jennifer Brinkman. I am the director of the Office of Criminal Justice Programs, which is within the Department of Finance and Administration. And today I'm here to just give a little bit of background on our office and what our office does. So our Office of Criminal Justice Programs, which we affectionately call OCJP, under the State Department of Finance and Administration, functions as a strategic planning agency that secures, distributes, and manages federal and state funds related to criminal justice and victim services. OCJP utilizes strategic program management, a structured process that looks 3 to 5 years ahead of daily grants management activities to identify the changing needs of Tennessee's justice system and the needs of victims of violent crime. OCJP tracks problems surfacing in the criminal justice system, monitors trends in Tennessee's communities, assesses the conditions of the state's resources, and measures the recent performance of OCJP-funded programs. To address crime and victimization in Tennessee, we manage a systemic year-round cycle for determining communities' needs, making grant allocation decisions, managing funded projects, and evaluating the results of those decisions. That being said, to perform these office functions, OCJP operates outside of the criminal justice process. We do not oversee court functions or criminal proceedings, nor do we have access to investigative files related to criminal proceedings. OCJP does not have the direct connection to or access to information related to witness protection or witness reimbursement. There is a current process we are aware of where county clerks and district attorneys can approve reimbursements and resources, but we are not a part of that, and we do not have expertise in that area. We also do not have information about any current funding for witness protection and relocation services, current allowable and unallowable expenses, nor do we take donations or private funding. And due to the confidential nature of the investigative records, again, we cannot determine the eligibility for this program, which is a function of the District Attorney General's office and/or local law enforcement. Because OCJP is outside of the criminal proceedings and determination of eligibility for witness protection, we would not be the best entity to promulgate the appropriate guidelines or rules for this program. This would insert OCJP into a process where we would act as the expert and set guidelines and rules when there's already a process and some form of regulations in place, thus putting OCJP in the role of an authority over the district attorney generals and the local law enforcement. So to insert OCJP in the process could result also in duplicative reimbursement, as we do not provide oversight of the DAs or the clerks, and we stand apart from the criminal proceedings. We don't have access to the day-to-day administrative work of these entities, and we do fund local community victim services programs that provide some of these services already.
Thank you very much for your time and being here. Members, do we have questions for our guest? Representative Griffey.
Briefly, thank you, Mr. Chairman. I appreciate you being here, and I appreciate the restrictions on OCPG. Let me ask you this, but you are a clearinghouse essentially for getting federal grant money and dollars and passing those through to other entities in the state. From your perspective, would it be more appropriate to try to address representatives' issues of the witness protection, try to secure federal funding, grant funding, pass those to the DA's conference and because the person dealing with these witnesses and so forth, or the district attorney's office and the law enforcement, they're the ones that probably have a better idea of who needs to be protective, what's the best way to provide the protection and the use of those funds. Would you comment on that, please?
Absolutely. OCJP actually already does pass federal funding through to the District Attorney General's Conference, as well as local counties. We fund about 20 different victim witness coordinators to work with the victims and the witnesses in these proceedings.
Thank you. Thank you, Mr. Chairman.
Representative Farmer.
Thank you, Mr. Chair. And just one question for our speaker, and thank you for being here, ma'am. Will you all be able to do what this bill is asking you to do? Do you have the capability to do so if we pass this law?
Not at this point, we don't.
Okay.
It would require additional state resources for positions and development of expertise.
Okay. And thank you, ma'am. That's all I had, Mr. Chair.
Thank you very much. Representative Hardaway.
Thank you, Mr. Chairman, and thank you, ma'am, for being here. Are you responding to the bill or the amendment?
Both.
Okay. And what is it in the amendment that you cannot do, that you don't currently do in terms of assisting in locating grants? I understood the issue that you voiced on and your hesitancy about developing guidelines and promulgating rules. But outside of that, tell me what else that you're having an issue with.
If we were to solicit extra federal funds to locate federal funds specifically for this program, we would then be required to have additional positions to manage those funds. And so that's my concern, as well as the expertise that we would have to develop. We would have to work very closely with the District Attorney General's Conference, which again, we already do, but it would take that time and effort that our office doesn't have.
Okay, and maybe I misunderstood your initial comments then. So you are capable of doing this. You're saying that you need additional resources in order to carry it out.
Correct. I'm saying that at this point, I'm not
All right.
capable due to the lack of resources.
Right, okay. But your office, the Office of Criminal Justice Program, your jobs, your mission is to find resources to help the rest of the agencies and nonprofits around the country, not the country, but the state, to do a better job of law enforcement and delivering justice to Tennesseans.
Yes, we do locate resources. We administer the block grants for Tennessee.
All right. So where it speaks to the information relating to a witness participating in a program receiving funds from the pilot program established by this chapter being confidential and not subject to disclosure under the open records law, you don't have any problem with that part?
Can you repeat that? I struggled to hear that.
That when it comes to how the information is handled, the non-disclosure, the confidentiality, you don't have a problem with that part?
The issue for us with the confidentiality is we don't have access to the investigative records to be able to monitor these grants. We don't have the authority to look at investigative records to verify that these people were in need of witness protection and were eligible for the program.
Okay, and the information that you would be receiving in a pilot program, and with all due respect, a lot of what we're talking about now is how the pilot program will bring the information back and what the program statewide should look like. And we're discussing now what this program statewide should look like. But the pilot program is to try to figure that out. And that sounds like what we're doing now, and that's not what I want to do. I want the pilot program to be able to experiment, so to speak, and then the evaluation, you do, your job as OJP is to evaluate what's effective, what's not, where your resources are going to be allocated that you're passing through, correct?
We evaluate the programs that we fund, yes.
Right. Okay. And that, in essence, is what I'm asking for you to do with the pilot program, to evaluate it, figure out if there are funds out there that would help to facilitate the pilot program, and develop guidelines for a statewide program that down the road. Is that feasible?
So again, I go back to, yes, our office will figure out whatever we have to do to implement something if it's put here. My concern is that we're not the best place for it because of what we don't have access to at this point and the expertise that we don't possess in this particular area. So again, we will develop as necessary. It's just that there's already a process in place that's with the District Attorney General's Conference for victim witness. They already have access to the investigative records, and that's my concern. To evaluate the project, if I don't have access to the records, I don't know if the victim or witness that got resources was in danger or was just pickpocketed and not in danger. I don't have the access to determine that the funds that I put towards the project were used for what the intent of the grant program is. That's my concern.
Okay, and just using your example, that evaluation of whether the witnesses are in danger or not in danger when they're brought into the program, and for my colleagues, the reason that I got into this is that we would have law enforcement show up at a crime scene. Everybody there may have seen what happened. Nobody is willing to commit to testifying, to serving as a witness, because they got to live there. The family lives there. They have friends. They got to go home. And by the time that it gets back to the DA's office, and they sit and they figure out the strategy, come back out looking for people, they're long gone. Nobody wants to be involved. So one of the main concerns here is when an individual is at a crime scene, that law enforcement would be able to offer under this pilot program immediate assistance without it going through a whole lot of red tape and evaluation. And that witness would receive resources right there on the spot that law enforcement would have discretion on in order to secure the safety of that witness and thus secure the testimony of that witness.
I think it sounds like a marvelous program. I don't disagree that it's a needed program. I'm just sharing that we are not the experts in this area, and we don't have access to ensure that the funding is spent appropriately. We have the ability to go out and make sure the funding was spent, but I can't verify the eligibility because I don't have access to the investigative records. But I would do the best that I could.
Okay, and that's all we're asking, that you do the best that you can. But it's intriguing when you say that you don't have access to the information, but you do have a working relationship with the DA's conference and with DAs.
Absolutely.
Okay?
Absolutely.
So you can count on them to give you the information that they can and to give you their assessment
Absolutely.
on what the end results are
Absolutely.
for the pilot program.
Absolutely.
And you would compile your data depending upon what information is provided to you.
Yes.
Okay, that's all this is asking. It's not asking for you to get into confidential information, is it?
I understand what you're saying, but I also know that when I am audited by the comptroller or others, I have to ensure that my grant funding went to eligible clients. And so that's my only concern. But I can figure it out. But that is my concern, is that when I'm audited, I don't have the ability. And I'm not the only grant-making agency in the state. There are other offices that do grants that may have access to those investigative records.
Such
That I don't
as,
know.
if you don't mind.
I don't know which ones have that access, but I know that you've got your DCS does grants, TBI has grant funding. I think the DA's conference, I'm not positive on that one. I'd have to go look. But there's a way that we can look at other state agencies that might have access to ensure eligibility.
Okay. That's interesting. That's the first time that I've heard that from your office. Mr. Chairman, that's all I have. I'm going to ask that the committee, if this is our last meeting, I'm going to ask that the committee would pass this bill. That it's one, as I read the information of support from DA Wyrick, I'm going to ask that we move it along, and I'm willing, if there's language that you think needs to be modified, I'll certainly work with your office. I've worked with your office before, and that may have been before you were actually director, but and willing to work with you going forward. Thank you. Thank you, Mr. Chairman.
Yes, sir. Thank you. Representative Griffey.
Thank you, Mr. Chairman. Let me ask you briefly, would it solve the issues you have with the monitoring issues if you were simply directed under this legislation to be the pass-through entity to get the grants from the feds, it's probably the U.S. DOJ, and then simply pass those through to the DA in Shelby County as part of the pilot program, and let the DA or the TBI there or the local law enforcement be responsible for compliance as far as from comptroller oversight and review? All you would be doing required to get the funds. If you get $1 million or $500,000, you can pass that $500,000 to the DAs, and it's up to the DAs to meet all the other grant requirements that or the specifications that go along with that grant from the feds. Would that solve the issue that I think we're bouncing around at?
Off the top of my head, I think that it would, because we would pass it through to Shelby County, and the county would be under county audit then.
Okay. All right. Thank you, Mr. Chairman.
Thank you. Any other questions for our guest? Seeing none. Thank you very much for being here for your time. We will go back into session. We're back on House Bill 2806 as amended. Representative Hardaway, you recognized.
Thank you, Mr. Chairman. And once again, I'll ask my colleagues to pass this bill along. If there's some tweaking to be done, then I'm, as I expressed earlier, I'm willing to sit down with OJP and put the appropriate language in that will ensure that when the comptroller comes auditing, that he holds the correct people responsible. And I think those in the end will be those, the end user of the grants. When they accept the grants, they accept the grants with conditions. And with that, Mr. Chairman, pending any questions, I would ask for an affirmative vote by my colleagues.
Thank you for that, Representative Hardaway. I'm going to go to Representative Howell for a moment.
Thank you, Mr. Chairman. I know I'm out of order, but I wanted us, the committee, to recognize a group of outstanding students from Baylor School in Chattanooga. I have some constituents whose children go to Baylor School in Chattanooga, and beautiful school, been there for many, many years, a 90-acre campus, a great private school, and just want to say welcome to this group of students. Let's make them welcome.
Is there any that you would want to have to give a speech while they're here?
I'm sure they could do that, Mr. Chairman. I'm sure they could.
We just pick a random student and ask them to come up and speak? No. Thank you for being here, being with us today. Any other questions for our sponsor on House Bill 2806? Seeing none, we're now voting to send House Bill 2806 as amended on the full criminal. Those in favor say aye. Aye. Those opposed?
No.
The noes prevail and the bill fails. If you wish to be recorded as a yes, please see the clerk. Next item on our calendar, House Bill number 2808 by Representative Hardaway.
Please record me as a yes, sir.
House Bill 2808 by Representative Hardaway.
Thank you, Mr. Chairman. Still having those issues.
We will need a motion and a second on this. All right, you are recognized on your bill.
Thank you, Mr. Chairman. The genesis of House Bill 2808 was really a very disturbing situation where we had a judge in a certain county that was making up laws and then giving directives for law enforcement to carry them out. I'm a firm believer that we could have avoided the tragic tragedies that resulted in juveniles being handcuffed and walked out of schools, juveniles who were picked up at their home, little kids, elementary school children, who had done nothing wrong. But the purpose of the bill is not to get into that, but just to make clear that if we had had the proper data collection system in place statewide, that those type of situations would have come to the attention of the administration and certainly to the attention of the legislature, and we could have taken the appropriate actions to ensure the constitutional rights of the families and the little children who were abused by the system. With that, Mr. Chairman, I'll ask for an affirmative vote.
Thank you for the explanation. Any questions for the sponsor on the bill? Seeing none, we're now voting to send House Bill 28, or excuse me, I do have some for testimony here. So if there are not any questions, we will go out of session to hear from Jim Lehman. You will introduce yourself for the record. You will have 3 minutes for testimony.
Thank you, Chairman, members of the committee. I'm Jim Lehman with the Department of Children's Services. The department did have a position of working with sponsor on this legislation. There was an amendment that was drafted and shared with me by Representative Hardaway. All the amendment did, the bill is written, asks these groups, the AOC, the Department of Children's Services, and the Commission on Children and Youth to jointly submit an annual report with this data. The amendment simply appointed AOC as sort of the head of making that submission of the report. We were kind of worried about there being too many chiefs kind of situation, and thought it could be improved by saying the AOC would be mainly responsible in collaboration with DCS and the commission.
Thank you for your comments. Members, we have any questions for our guest? Representative Hardaway.
Thank you, Mr. Chairman. And Mr. Lehman is correct. And somehow that amendment got lost in the mix. And it does just take care of the too many chiefs, not enough Indians, and just having AOC to actually lead the effort. Mr. Chairman, I'll ask if the committee, if we can either make a verbal on that, or if the committee would trust the sponsor enough to pass it along. And I assure you that Mr. Lehman and I are already on the same page, and we'll be able to have that amendment ready for submission to the full committee.
Thank you for that, Representative Griffey.
Thank you, Mr. Chairman. I had just a couple of quick questions, and Mr. Lehman, you may know these. Are we already producing a report that already gathers this information in some other format? Is this going to be a duplicate effort, or if you know? Because this is going to be a reenactment, I believe, of a 2019 report. And I agree with your comments that we ought to put the AOC probably as the lead on the report and have the other agencies simply assist.
I'll have to ask the experts in my department. I'm not sure if this is something that's already have been collected. I know that I don't believe there were concerns, at least on our part, with gathering this data, for the piece that we can gather. But I'd have to ask, Representative.
Representative Hardaway.
Thank you. And we had, in the situation that I mentioned earlier, one of the problems is that there was information that was not submitted, period. Wasn't submitted in a timely fashion, just was not submitted. And that's one of the ways rather that we want to get to that is through the reporting requirements. And do you have comments on that, sir?
I don't. I'm not aware of that. Representative Hardaway, I'm certainly happy to ask about that. If there was anything that we were lacking on submitting, or I can ask. I can take that back to our folks.
But you would agree that if we had reports that are annual reports and a county or a jurisdiction failed to provide that information, then having the requirement in place will bring that to light. We would know that somebody didn't file their report.
Sure, if there's a requirement that that each county or court or system file the report, and that's required, then I guess whomever is responsible for maintaining all of those reports would know if someone didn't file it.
And bringing it to the attention of the legislature would enable us to do our job to provide the oversight for the different departments and agencies, and to ensure that our children are being taken care of properly.
Yes, sir.
Leader Lamberth, you're recognized.
Make a motion to go back into session.
Okay. Without objection, we'll go back into session. Any questions for the sponsor? Leader Lamberth? Previous question. We move previous question. Any objection? Seeing none, we're voting on sending House Bill 2808 on the full criminal. Those in favor say aye. Aye. Those opposed? No. The noes prevail. The bill fails. We'll move to item number 10, House Bill item number 12, pardon me, House Bill 2010 by Chairman Faison. You're recognized.
Thank you, Mr. Chair. Committee, if you'll bear with me just for a minute. William Gladstone was the Prime Minister in Great Britain in the late 1800s. He coined a phrase that's used today. This phrase was, "Justice delayed is justice denied." Now, often we take that from a standpoint of a victim, saying of the victim or the victim's family, if justice delayed, then it's justice denied for that. But the bill that you have in front of you today is a bill that there's times that justice has got it wrong, and an extended gets it wrong. And we, as a legislature, the ones who set policies, should want to make sure that justice isn't delayed for the victim or for the person who's innocent, because it's been denied. Over the summer, I had the occasion with Chairman Curcio to meet a man who was put in prison for a crime that he didn't commit, went to death row for a crime that he didn't commit. Currently, according to our TCA, to be able to navigate for a man who has been found guilty of something that he did not commit, and future evidence comes out that in fact exonerates him, that path is difficult. It becomes incredibly more difficult for people who don't have a lot of money. I speak for people in East Tennessee who struggle financially. If you're in the justice system in America and in Tennessee without financial resources, you find yourself in a place that's almost impossible to navigate. This guy that Chairman Curcio and I have listened to his story, he was eventually exonerated, got out of prison, but he still has a felony on his record. And unless the governor gives clemency, even though all the stuff was done, the DA said, we got it wrong, we've got him out of prison, he still has a felony on his record. I brought a bill that says, hey, we need to have some type of avenue for the have-nots who don't have this huge amount of bank account, can hire the best attorneys that money can buy. Have an avenue for them to be able to get out of it. Now, the DAs, they fought this viciously. They worked and made sure it got killed in the Senate. So that's why I'm not asking for a vote today. But I want you to know, they say, well, it doesn't happen very often. They said in my office, said in Chairman Curcio's offices, this doesn't happen very often. And my question for them and for y'all, that I believe we need to study this. If it happens once, it's worth it. And why is that? Because if it was your child, if it was your dad, if it's somebody that you loved who was sitting in prison for something they didn't commit, and then evidence came out later on that they in fact were innocent, would you not want an express lane to get them out of prison, an express lane to get the felony off of their record? Right now in Tennessee, we don't have an express lane. Justice delayed is justice denied. And I would tell this committee and those watching the DAs, it's not all right for us as a state to have a policy that it's so cumbersome for just the average guy that he can't get out of something that he was innocent of in the first place. And I would encourage us to make sure that they come to the table and not just go get a DA to work somebody in the Senate, but come to the table and say, hey, we have to come up with an avenue for the have-nots to be able to get out of a felony that they never committed in the first place.
Thank you for that. Chairman Curcio.
Thank you, Mr. Chairman, and I appreciate the sponsor's passion for this. And I just wanted to add some context here. I did meet with my constituent who unfortunately was convicted and sentenced to 15 years for a murder that he didn't commit, for a rape that he didn't commit. Now, the rape charge was dropped. He pled to manslaughter, but he didn't commit any of it. And there was DNA evidence that proved that he didn't commit any of it. But as Chairman Faison has outlined, there's not a clear legal avenue to move forward, even though you had folks inside the District Attorney General's office saying, yes, we got this one wrong. We recommend that he be released immediately. There's not, I mean, I think the average Tennessean is surprised to hear that there's not, you know, I asked folks at a Rotary Club I was speaking at one time, I said, what do you think would happen if you were sitting in prison for a murder and DNA evidence came forward or scientific evidence came forward that proved that you had absolutely nothing to do with it? Not that you were guilty of a lesser crime, but that you just physically did not do it. And they said, oh, well, you just get to walk out and knock on the judge's door and say, hey, you got the wrong guy, and then they let you go. Nope, doesn't work that way. There's not a legal avenue for innocence. There's a writ of quorum nobis, there is clemency, those avenues are available, but they're very difficult. You know, the governor's looking at a needle in a haystack, basically. So what I loved about this language is that it talks about new evidence that was never considered before, wasn't available at the time, and if it were, no reasonable judge, no reasonable jury would have convicted this person. So I won't be here next year to have this conversation, but I encourage Chairman Faison and others to continue looking at this. We're not saying that people do this intentionally. It's not an intentional bad act. But again, if there's even a small percentage of cases that end up this way, I just want to make sure we have an avenue to look at them. So thank you, Mr. Chairman, for the time.
Thank you. Brief response.
Thank you, Mr. Chair. And with that, I'll take the bill off notice.
Okay.
Committee's indulgence.
Representative Hardaway, briefly.
Thank you, Mr. Chairman, and I want to thank the sponsor for the bill. I agree, justice delayed is justice denied, but the fact is that the justice that's denied is the justice not just to the individual who was innocent and convicted and suffered the sentencing penalties, but also for the victim, the victim's family, who have no closure because the case was considered to be solved, and the perpetrator is still roaming the streets and perhaps even committing more atrocities. So I salute you on bringing the bill, and I'll be there to work with you next year. Thank you.
Thank you very much. Without objection, House Bill 2010 will be off notice. Next item, House Bill number 14, House Bill 2751 by Representative Towns. You have a motion. In a second, you are recognized.
Mr. Chairman and members, thank you. As you all know, if you look at the news around the country, you see these knuckleheads driving up down the highway, shooting out of the cars, okay, for no apparent reason. Short-tempered because somebody cut you off or whatever, somebody flip you off or what have you. And it's a thing that's happening in Tennessee, happening in Shelby County, but it's happening everywhere. And what this bill seeks to do is just simply, increase the penalty. Now, just a little bit ago, the press has called about this particular bill. And I know on the other side that my senator has not yet put it on, but I'm contacting him to see if we can put this bill on notice on the other side. There's a great deal of interest in it. Don't think so. Y'all look like bobbleheads, man. What is that?
Thank you, Mr. Chairman. And to my friend, you've served many years down here. I mean, they're on their final calendar over there. I think they're having their final meeting today. You've worked valiantly on this, and I applaud your efforts. But for today's purposes, if you wouldn't mind taking it off notice, simply because the Senate has not acted on it, you've done everything you could have done to get this presented. But unfortunately, it takes both chambers, and it just didn't happen at this juncture. But I applaud your efforts in this, and you've brought bills like this in years past that we've all supported. But it takes both chambers to get it done. So thank you.
And factually, as you just stated, I do understand and I do know. And last leg of the race, there's no chance. I understand, but still, on the record, we want to make sure that we put it on the record for the ability to bring it back next year, because something has to be done, gentlemen, ladies and gentlemen. It just has to be done, and it goes all the way down to forfeiture of the property, just the whole nine. You all read it. You see what it does, and it's just out of control, and it's dangerous, But thank you, and I will take it off notice. I don't know if you have anything, but I will take it off notice.
Well, thank you. Thank you for your work, Representative Towns, on this subject. And without objection, House Bill 2751 will be off notice.
Thank you, members.
Thank you. Next item on our calendar, number 15, House Bill 2790 by Representative Shaw. Seeing he's not here, without objection, House Bill 2790 will be off notice. Number 18, House Bill 2437 by Chairman Farmer, without objection, off notice. And that brings us to the end of our regular calendar. We'll take up item number 1 on the special calendar, House Bill 673 by Vice Chairman Freeman. He is not here.
Did he say special calendar?
Without objection, it will return to the clerk's desk. Item number 2, House Bill 1565 by Vice Chairman Freeman. Without objection, return to the clerk's desk.
Mr. Chairman, I'd like to make a motion we reconsider actions on House Bill 673 by Representative Freeman, who's in the room.
We'll need a second. Okay. We'll now be voting to reconsider our actions on House Bill 673 by Vice Chair Freeman. Those in favor say aye.
Aye.
Those opposed, ayes prevail. We've reconsidered. Now we're on House Bill 673. We'll need a motion and a second on that bill, please. Second. Thank you. There's an amendment code 16908. You wish to proceed with that amendment?
Yes, sir. That's exactly what I have.
You have a motion on the amendment? Second. There's a second. You're recognized on your amendment.
Thank you, sir. This is a bill that I've been working on for, probably going on 3.5 years now. And I'm going to describe a little bit of the problem and then tell you what this bill hopes to do. So currently, within the victims of rape and sexual abuse can have an advocate that can come and sit with them as they are getting their rape kit done. This person is sometimes a trained therapist, sometimes they're not. They are advising them on what their legal options are and really just helping them understand and work through this process. During this extreme moment of trauma, the victim may say things like, I should have known better, or I shouldn't have had that last drink, or people warned me, or any number of statements that could be used against them when that case goes to court. These victim advocates are subpoenaed to go to court and testify against the same person that days, weeks, months, a year earlier, they were literally holding their hand and helping them, and they're put in impossible situations. We currently provide this protection to lawyers, to doctors, to actual therapists that if they have that fiduciary responsibility. And what I would like to do is allow for victim advocates to have the same confidentiality and not be called into a court proceedings to have to testify against who was their client. And with that, I'd like to answer any questions.
Leader Lambert.
Thank you. As I was going over the amendment, and I just want to understand, you mentioned lawyers and other professions that have confidential communications with their clients, and that's protected as confidential communications. The issue that I have with the amendment and with the bill at this juncture is that it doesn't make that information confidential anywhere except court in the bill. If you don't mind, why is that? Because if someone can share it on Facebook, or they can share it with a friend, or they can share it at the grocery store, they can share it at church or anywhere else, but the only thing we're protecting is that they're not subpoenaed to share that same information in court, it just seems to kind of defeat the purpose. I mean, the example of a lawyer, I mean, if I'm having a confidential conversation with a client, I can't share that information with anyone without their permission. Now, if that's what the bill said, I mean, that would be much stronger. But to limit it just to court seems almost bizarre to me. So is there something I'm missing, if you don't mind?
Yes, and thank you very much for the comments. It's a very specific and intentional restriction. These are the situation that you're speaking of, where it's a confidential arrangement, is they are sharing with you potentially confidential information that the public at large does not need to hear. What the confidentiality that I'm trying to protect is, again, a victim in a moment of extreme trauma sharing something that they haven't had an opportunity to process yet, and that is then used against them in a court proceeding. And so it's not that the information is necessarily secret. Many of these cases, it's in the news, people talk about it very openly. The issue is that this victim advocate does not need to be used against them in the court.
And thank you for that. But unless it's going to go all the way and make this information confidential and truly protect those victims from that information being out there, I can't support the bill as written. I mean, where you're headed seems like a really good place, but it just seems bizarre to me that information could be shared with anybody else. But in a court of law where we're trying to get at the truth, and Chairman Faison was just in here a while ago talking about, someone wrongfully convicted being trying to, prove their innocence. And if it's not confidential, then it's not confidential. If it is, then fine, go all the way and say it's confidential everywhere. But if we're not willing to do that, it just seems bizarre to say you can talk about it with anybody else except in court. So that's just my only issue.
And so I would ask you this question: Are you and are doctors and lawyers and other therapists, are they legally bound by that confidentiality, or is it part of their ethics? And I know within therapists specifically, it's not a legal or civil violation. It's part of their code of ethics. So they can be found in violation of their individual ethics if they share the information. But this is simply within a legal setting.
And you're absolutely right, but you're covering much more than just those professions that have an ethical obligation that will lose their license if they share that. So if you were just focusing on professions that have that ethical obligation and they're licensed professionals, but your bill goes way beyond that into other professions that, to my knowledge, don't have that requirement. So again, if it was just as lawyers are, you're ethically bound not to, then yes, that would solve the issue. But it's a very broad brush that you're painting with here, and all I want as an attorney and as a legislator is to get to the truth of a matter. And there are, some protections in here where someone could be called to testify. But again, unless it's confidential everywhere, it should not be blocked from being able to be brought into court so that the truth can be found. I mean, that's what matters. And I want any victim of crime to be shielded from having to go through that process. But it is a critical process that we have to protect everyone's rights, and particularly someone charged of a crime. So unless it's confidential everywhere, I just can't see how we would make it confidential just in court.
Sure. So, and I'd like to draw everybody's attention to Section C, I believe, and Section C does allow, if it's relevant to the court case, that they can come in and speak to a judge. If the judge deems it appropriate, it can be heard. And if the victim advocate did in fact make a claim against somebody, they would absolutely, by constitutional right, be able to cross-examine them. So it doesn't disallow anybody from defending themselves. This is simply allowing somebody who, again, in a horrible moment of deep crisis, they say something that they have not had an opportunity to fully process, and that cannot be used against them in the court case. And the victim shaming that I have heard in the past, somebody says, I knew I shouldn't have worn X, Y, or Z. I knew I shouldn't have been there. A person, regardless of what they're wearing, how much they've had to drink, who they're with, does not have a right to be raped. It doesn't matter. You can make every bad decision in the book. You could fall down in somebody's car completely naked, and you do not have a right to be raped. You can be in the middle of the act and say, stop. You do not have the right to be raped. And all this does is protect that person who is trying again to deal with this trauma and having a private conversation with an advocate who is helping them through the process to not have to then come back and use their own words against them in testimony. And I fully appreciate the leader's comments, and I appreciate the spirit in which he's offering them. But I have worked with multiple stakeholders. We have changed this probably 5 different times to get everybody on board and okay with it. And I believe that the bill as it stands and the posture it is today is the best way for us to make sure that these victims of rape and sexual abuse are protected in a court of law. And with that, I would like to answer any other questions.
Thank you for that. Representative Griffey, briefly.
Thank you very much, Mr. Chairman. This is the problem I have with this bill. What this bill would do if a victim advocate is with a victim and they're sitting around the hospital and waiting for the rape examination to take place or something like that, and potentially fairly recently after the attack or whatever, the victim may make certain statements about the potential perpetrator or the perpetrator, and they might make a statement that say, well, I think the guy, he was really heavy set or something like that or whatever. And then, 6 months or, 9 months, a year later down the road, they arrest some other guy, and it's not a heavyset guy or something like that. But a defendant is entitled to know what identification statements the victim made about the perpetrator in order to defend himself. And in this scenario that I portray and paint, I don't think it's really that unlikely to occur. The victim advocate would have to come forward and disclose all this before the defense counsel or defendant would even know to get the person on the stand. And I read the bill, and I think I'm reading it correctly. You've got to have the victim's consent before the victim advocate can come forward and disclose all that. So to me, this is a bill that's going to potentially hide the truth from a trier of fact, and it really concerns me that's my concerns with the bill. Thank you.
Representative Freeman.
Yeah, and again, if you read the complete bill, Section C says, does not limit the ability of a court to compel disclosure if upon motion of the party, the court determines after an in-camera review that, and it goes through all of the reasons within. And the job of the victim advocate is not law enforcement. They are not a law enforcement, they are not making the case against their client. That is not their job. Their job is to make sure that this victim of rape and sexual abuse is given the help that they need in their great time of pain.
It's also not the job of the victim advocate to hide the truth so potentially a person on trial gets unfairly convicted of a crime. That'd be my response.
And law enforcement will be on, part of the process and part of the SANE kit and the rape kit testing is an in-depth interview. And if that person would like to press charges, they have to make a case with law enforcement on what it is. This is not, listen, I wish that rape and sexual abuse wasn't a thing. I wish that this was not something that we were having to deal with, but it is. And having someone at their lowest moment saying an offhanded comment that is then used against them in a court of law is not keeping in the spirit. We already give this protection to if a nurse goes into the room and says it. Do you have an issue if the same person says it to a nurse?
Here's my problem. You're requiring a defendant or defense attorney to know about certain statements that may or may not have been made to the victim advocate. They are not there. They have no idea what was said. And what's wrong with simply if someone's allowing statements to come in, I shouldn't have had that last drink or something like that, that's on the judge in the process. But if it's identification purposes or something like that, that's a whole nother matter, because that matters who did the offense, who committed the crime, and who might go to prison for a crime, whether they're innocent or not innocent. So that's this, and this bill is going to protect potentially exculpatory statements from getting to the defense so someone can vigorously defend themselves against potentially a wrongful charge.
I just couldn't disagree more. We have cases where there is actual DNA evidence, there is photographic evidence of abuse, and people are not going to jail. And if you believe that not allowing a victim advocate reporting on an offhand comment that somebody was overweight is not going to put them into jail, the problem is significantly larger than that.
Thank you for that, Representative Beck.
Mr. Chairman, we have Kathy Walsh here with the Victims' Rights Coalition. Would we like to hear from her on this subject?
Representative, I would love to have her opinion on the matter, but she is not on our list according to committee rules, so we won't be able to hear testimony from her today on that.
Okay, I'll abide. Of course, I always abide by committee
Absolutely.
rules. Number one. Number two is, to the sponsor, I can kind of see why you don't make it confidential the whole way through, because a lot of these victim advocates have to work to get services for that particular victim. And in doing that, they might reveal something like, she told me that they didn't have food that night, and that's what set him off, or something along those lines. And if she doesn't go to the food bank and say, well, she doesn't have food, well, then she would be not able to communicate what the real needs of the victim are. So I fully support your bill. Thank you.
Representative Hardaway, briefly.
Thank you, Mr. Chairman. And to the sponsor, I think I heard you saying that the same confidentiality guidelines that apply to lawyers and doctors in the same case is what you're seeking?
Not exactly. It's, but my point stands. They do have confidentiality, and it's expanded to or extended to other members who these victims will come in contact with.
So what you're getting at is that the victims are, in essence, victimized again because they're in a vulnerable state and may make a statement in that emotional, traumatized state that they may want to withdraw or think better of once they've calmed down or really settled down. And this is just an effort to keep that initial response to the advocate confidential, so the victim is not victimized by their own trauma, their own emotional outbursts.
Yes, sir. And to further that point, many of the confidentiality agreements that these people are held to are part of their code of ethics. The legal aspect from not being compelled to present and testify in court is exactly what I'm trying to address here. And yes, sir, that's exactly correct.
All right. Well, I've witnessed too many situations where the victim was re-victimized, and I support your bill 110%, sir.
All right. Thank you, Chairman Curcio.
Thank you, Mr. Chairman. I move previous question.
Previous question's been called on the amendment. Any objection? Seeing none, we're voting on adopting Amendment Code 16908 on the House Bill 673. Those in favor say aye.
Aye.
Those opposed? Ayes prevail. You adopt. We're on House Bill 673 as amended. Chairman Curcio.
Thank you, Mr. Chairman. I move previous question.
Previous question has been called. Any objection? Seeing none, we're voting on sending House Bill 673 as amended on the full criminal. Those in favor say aye.
Aye.
Those opposed? No. The ayes prevail. You move on to full criminal. Next item, number 3, House Bill 1308 by Representative Chisholm. Without objection, be returned to the clerk's desk. Item number 4, House Bill 1574 by Representative Stewart. Without objection, return to the clerk's desk. Item number 5, House Bill 802 by Representative Griffey. Without objection, return to the clerk's desk. Item 6, House Bill 2319 by Representative Hall. Return to the clerk's desk. Item number 7, House Bill 2578 by Representative Dixie. Return to the clerk's desk. Item number 8, House Bill 2034 by Representative Harris. Return to the clerk's desk. Members, House Bill 1830 by Representative Parkinson will be returned to the clerk's desk. And House Bill 1 by Representative Hardaway will be returned to the clerk's desk. Members, that brings us to the end of our committee. I appreciate each and every one of you for this year, for your hard work, diligence, and dedication in the world of criminal justice and the issues that we faced. Chairman Curcio, you're recognized.
Thank you, Mr. Chairman. I just want to say thank you for your hard work. I know when a bill gets to full committee, it's been vetted, and appreciate the work that you've done. And since I won't get the opportunity to work with you again next year, it's especially bittersweet. So thank you for all your help this year.
Well,
Great
yes,
work.
sir. Thank you. Thank you very much. We will miss you. Members, anything else before we adjourn? Seeing none, we will be adjourned, subject call to the chair.